Yes. When do you want? 20th, 30th. In site, vacant site or building? Nim perpetual injunction reject ಆಯ್ತು. ಅವ್ರು ಮಾಡೇ ಮಾಡ್ತಾರೆ. What is the urgency in? Your suit is dismissed. But what is your right? You are able to hear me. What is your right? No, on what? Sale deed. You have a sale deed. Next week. All right, we'll have it on 30th. No, tomorrow may not. How are we placed tomorrow, madam? Tomorrow or day after? Tomorrow. Office objection. After a week only. What is the urgency? Objection is, office objections. Go and clear it. Okay. ಅಲ್ಲಿ ಬರೀರಿ ಅದರಲ್ಲೇ ಬರ್ದು ಅವ್ರಿಗೆ ಕೊಡಿ. ನೀವಲ್ರಿ ಅವರೇ ಅದರಲ್ಲೇ ಬರೀ ಕೋರ್ಟ್ಗೆ ಮೂವ್ ಮಾಡಿದೆ. ನಿಮ್ಮ ಹೆಸರು ಕೇಳ್ತಾ ಇದಾರೆ, ನಿಮ್ಮ ಹೆಸರು ಬರ್ದು ಕೊಡಿ, ಸೈನ್ ಹಾಕೊಡಿ ಅಂತ ಹೇಳಿ. Next week only. How it's not possible? Next week.
And they are now trying to eliminate the problem.
No. Next week. Earlier also you moved a memo for posting, not come up. Next week we'll take it up. Alienation will be lispendence only. What happened? Your partition suit. Who are you?
Number one had filed a partition suit against her brother, and we had purchased
30th. Kodi. Take it on 30th. All right. Withdrawal. Post it tomorrow or day. Yenamadu. You have to tell. So what are you? Why are you moving it here? For what? I'm unable to understand your submission. Now you're moving this for what purpose? ನೀವೇ ಹಾಕ್ಬೇಕು ಪೇಪರ್. ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ಗ ಅವ್ರು ಬರ್ಲಿ, ಮತ್ತೆ ನಿಮ್ಗೇನು ಅರ್ಜೆನ್ಸಿ? ಸ್ಟೇ ಆಗಿದೆಯಾ? ಇಲ್ಲಿ ಸ್ಟೇ ಆಗಿದೆಯಾ? ಅದು ಗೋ ಅಂಡ್ ಎಕ್ಸಿಕ್ಯೂಟ್. ಎಲ್ಲಾಗಿದೆ? ನೀವೇ ತಾನೆ ರೆಸ್ಪಾಂಡೆಂಟ್, ಸಕ್ಸಸ್ಫುಲ್ ಪರ್ಸನ್ ಇನ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್. ಯು ಆರ್ ಸಕ್ಸೀಡೆಡ್ ಅಲ್ವಾ? You are not clear. You read what it is and then submit later on. Maybe at 1:30 or tomorrow. How many persons? 2 persons. Yes, Jana, either a family member. 10 persons. 10 daughters. And how many brothers? So all of you will be entitled to one share, or each one will get. What has happened in the trial court? So what is the relief granted in the trial court? Which year is the RFA? 17. Now you are filing what? IA? IAs are not heard. Final hearing irbekama 2000. All right, have it next week. Put it next week. Uh, 30th. Is it listed today? Or it will come up tomorrow, day after? Next week. Ivatidya. You want to? All right, put it tomorrow, day after. Who are you?
Properties were largely in Laka. Lodging for the driving and initially offered. After passing of the finish the half sharing the Laka head. Then it can receive a province for sale of therefore, for a direction for exponents to change their part of Laka head so that it can really operate in the land.
Sale can be avoided. What is the decree passed? What is the decree passed? How much share? You're satisfied with that? Now you have filed some application for hearing. All right, those applications are served to the other side. Served. All right, we will list it on someday. Okay. We'll have it on 10th or 11th. Which day you want? Which day you want? When do you want it? 10th is a reopening day. We'll have it on 11th. 11th. He's an advocate or who is he? Student. When do you want? Next week we'll have it. Next week.
Page number 6, number 23, page 7 and 8, page 8, number 29. What is serial number 1? I am here.
So now you are filing the amended cost item. Have you served the copy on the other side? Who has to file the synopsis and list of authorities? Burford, Learned Counsel for the appellant. File it in the registry. Is ready with the. Have you carried out the amendment? Ready with the amended cost title. Submits that he'll file it in the registry. Same is permitted. Release this matter after 2 weeks. Huh? Your respondent. For what? Settlement ಆಗಿದೆಯಾ? Passed over. You are appearing for appellant. Burford. Sorry,
Number 11, Srinivas Raju.
Learned Counsel for the appellant has filed a memo along with the newspaper publication published in the Hindu and Udaivani daily newspaper, of which edition? Of Bangalore edition, dated 25/8/2022, wherein the service of notice was effected to newspaper publication to respondent number 11. Full stop. Respondent number 11, Shri M. Srinivasa Raju, is called out. There is no representation by himself or either through his counsel. The notice taken out by way of paper publication is held as sufficient and is deemed as served. Registry to show the name of respondent number 11 in the cost list as served. Yes, what is the next? Now, what about some complaints on IE vacating her? Copy kottilla nimge. Learned Counsel for the respondent 1 to 3 to serve copy of the IA 1 of 19 to Learned Counsel for the appellant. So all services complete. It has to come up for admission. 2018 matter. Bit agidya. This matter for hearing. Non-compliance. 3 weeks time granted to comply with the objections. 2 weeks time granted to comply. Same order. Then appears for the appellant to release this matter after 2 weeks.
Number 8, Rajeshwari PN.
2 weeks time granted to comply with the objection. Same order. Same. 2 weeks time granted to comply. Have they replied? The postal record says they have received. Learned counsel for the appellant. What's your name? Aniraj Kashyap files a memo for retirement along with 2 documents. Being noticed to the appellant and the postal receipt for having received the said notice. It is stated by learned counsel for the appellant that despite several calls and notices to the appellant, no instructions are provided to the appellant to proceed in the matter. In view of lack of instructions, he wishes to retire from the case by issuing a notice of retirement, which is served on the appellant, and the acknowledgement is also placed before the court along with postal receipt for having sent the notice. To stop. In view of the same, registry to issue court notice to the appellant. Relist this matter on the 2nd, 3rd week of October. We'll give one more chance if he comes, then after that you can.
I'm ready.
Yes. 2 weeks. 2 weeks time granted to comply with the objections. ಅದು ಮೈಕ್ ನಿಮ್ ತಲೆ ಮೇಲೆ ಹೋಗ್ತಾ ಇದೆ, ಕೆಳಗ್ ಮಾಡಿ, ಅದು ಕೆಳಗ್ ಮಾಡಿ. ಯು ಕ್ಯಾನ್ ಬೆಂಡ್ ಇಟ್ ಸಮ್ ಮೋರ್. ಆರ್ ಯು ಹ್ಯಾವ್ ಟು ಗೋ ಟು ಸಮ್ ಜಿಮ್ನೇಷಿಯಮ್ ಅಂಡ್ ಇನ್ಕ್ರೀಸ್ ಯುವರ್ ಹೈಟ್. 2 ಮಾಡ್ಬೇಕು, ಒಂದು ಅದನ್ನ ಕೆಳಗ್ ಮಾಡ್ಬೇಕು, ಇಲ್ಲ ನೀವು ಹೋಗಿ ಎಕ್ಸರ್ಸೈಸ್ ಮಾಡಿ ನಿಮ್ ಹೈಟ್ ಇನ್ಕ್ರೀಸ್ ಮಾಡ್ಬೇಕು. ಸೊ ಡೋಂಟ್ ವರಿ ಅಬೌಟ್ ಯುವರ್ ಹೈಟ್, ಜಸ್ಟ್ ಪುಲ್ ಇಟ್ ಡೌನ್, ಇಟ್ ಕ್ಯಾನ್ ಕಮ್ ಟು ಯು. What is the jurisdiction value, madam? So it is more than 20 lakhs.
Yes.
Then it has to go before DB. Al Khalisada. Then what is your name, madam? Vakalatidya nimdo. Learned counsel Srimati Annapurna H is present before the court. He submits that the value of the subject matter of appeal is more than 15 lakhs. Hence, in view of section 5(1) of the Karnataka High Courts Act, the appeal would have to be placed before the Honorable Division Bench for consideration. The registry Full stop. Registry to place this matter before the Honorable Division Bench for consideration. Full stop. Then counsel for the appellant to file second set. Muniraj, 3 weeks time granted to comply with objections. Let us go before DB. Valuation ಎಲ್ಲ ಹೇಳಿದ್ದೀರಾ? The plaintiff's appeal. Correct. So ನಿಮ್ ಶೇರ್ ಎಷ್ಟು ಬರುತ್ತೆ? Is operating this. Close this window. All those people can get it rectified. So we'll send it to DB, sir. The not counsel for the appellant is present before the court. He submits that the value of the subject matter of appeal is more than 2 crores 15 lakhs. And the plaintiff share works out to more than, and the plaintiff share works out to more than 20 lakhs. Accordingly, this matter would have to be placed before the Honorable Division Bench for consideration. Full stop. Registry to place this matter before the Honorable Division Bench for consideration. Then full stop. Learned counsel for the appellant to file second set. You want to this court to consider IA2 for stay.
Thereafter, the next move we had created that so therefore, this is admitted. And I can respond to the one as well. Now, have filed the suit for election against me. Therefore, not I.
So what is the objection?
Again, look, instead of saying who is 4,500 or 4,000, I have tomorrow.
All right. All right. You have served the copy. So that is the only objection. All right. So now what you are seeking in IA? Stay of judgment. But notice is not served to R3, 4 and R9. So who is the person who had filed the suit? Assistant Madhi. 1 minute. Three and four. Wait.
R9, no, sir.
So, 3, 4, 7 and 9 about it.
7 already served, 9.
9 matra. 7 is there. Madam, R2, 5, 6, 8 item is delivered. So we will take them as health notice held sufficient. That is with so they are all served now. No, 9 is not served. 9 you may have to take notice. So plaintiff is the first respondent. So he had filed the suit.
Therefore, he has filed RFA of
That is also here. 16.1. That is 1734. Is filed by plaintiff on dismissal of the suit. Dasappa.
I'm saying what
1 minute, let me just understand this. So this suit, what is that? This suit is dismissed. Plaintiff suit is dismissed and he has filed the 16.1 appeal. You have filed appeal for what?
coming into village. Because what has happened? In earlier loan, there was a fraudulent transfer made by the respondent number one, that is the plaintiff. Not that, it was set aside after contempt.
In which suit? In which suit?
There is a OS 5,712 of 1996 and OS 903 of 1997.
Oh, 5,712.
9 days of 1997,
Ah.
5,712 of 96.
So in these two suits, the will came to be proved.
In that case, the bill was not proposed at all. Hereafter, they filed the appeal also. That also came to be discussed.
So these suits, two suits were filed by whom?
Thereafter, the plaintiff, the defendant number one, who lost the suit there, since it held that it is the mother's property. We find a food for partition waiting something to say. In that, my party was took my advice, I said, forget the chair is at that time, this defendant number 4, before this wanted to go,
Defendant or respondent?
defendant number 4 in the 4.
Ah.
That was defendant number 4.
Ah.
In the 4 filed by defendant.
Ah.
Tell that will be true. Whereby he is stating the property has become his absolute property.
Where is that?
That is the judgment under charge.
No. Where is that finding? Where is that finding?
Finding. So number 3.
Page. Ah. Yes.
Second number 2 is that the mother of the party instead of
Affirmative.
now he is saying that it is
He has filed some execution also.
what we are saying. For election against me. Because in the demand, I am the only person saying. Take a different number. That's why I am challenging these.
Where is the detailed reasoning of that issue number 3? Para 11.
All these concerns are before in the earlier court. But we did not think about it, we did not discuss about this bill.
Ah.
There are 21 page increases.
Para
There are 21 page increases.
page. Yes.
Is also not obeyed to make the practical. In 2012, the definition of what is not other than world in the regard to the federal. Only in the defense sector we are able to definitely have not supported the he has stated that he has not drafted and he has been both of the
Yaro, who's DW3? DW3 Yaro. Rudramma. Wife of? That she's a party. Ah.
who has, according to them, who has drafted the bill.
She advocate. Hmm.
Right outside the court, that will be.
Hmm. She has denied. She has not supported.
That's right. There we have denied, I have not written this in.
Yes. DW4 is brother-in-law.
TW4 is brother-in-law and TW5 is a mother.
No. Read it. DW4 is brother-in-law of defendant number.
TW5 is a mother.
Madam, just read it further. Read it. Read it. DW4 is the brother-in-law of defendant number 2, and as such,
TW5 says that the law does not regarding the content of the list. One. By including other things. There are periods
hence, what is this? It says serious suspicious circumstances and will is proved.
This was the best in the year. They have produced these books Hyderabad in 2011.
Hmm.
And they that he has represented. These documents are showing there.
All right.
Then he denied. So what is that behind? Exactly. And the process
So based on this will which is being proved in favor of defendant number 2, he has filed an eviction suit against you. You're a family member. Which defendant are you? 4. So defendant number 2 has now filed a case against you for ejectment based on the will proved in this case. Whether is it your case that the defendant number 2 and this plaintiff has colluded? No, because the suit is dismissed. So what is your prayer in the appeal? No, appeal. You have filed the appeal. The suit is dismissed. You cannot ask for setting aside. Suit is dismissed. You are a defendant. So what is there to set aside? It is in your favor. No. The suit is filed for what? Suit is filed for what? Declaration partition. Yes.
taking back all freedom of the mark for effect.
1/6 share ಕೇಳಿದ್ದಾರೆ. Nothing is given. Is it the finding of the trial court that it is not joint family and it is a self-acquired property and Lingamma?
He was having 6 children. So everybody is entitled to contribute. Now we go, the dependent number 2 having audited. He's bringing letter to fight over all the others.
ಇವಾಗ ನಿಮ್ಮ IA is to stay the operation of the judgment and decree. Whether that operation of judgment and decree will you benefit by staying that operation?
Cannot get that, I cannot find like that. So now on the basis of statement, she has right.
No, staying the operation of judgment and decree of dismissal.
So I cannot now see for stay, because they are already had.
He has filed a suit against you. You based on this. What is the stage in that? All right. What was your contention in the written statement? In the original suit of 4,500, you have not filed statement.
But I was, my case is, I was prevented my dependent number 2 nature. Because saying that everybody will get 100%. Saying that everybody will get 100%, we are not allowed him to enter the court at all. Just that he will look after my case. After he is there, no evidence was also recorded. After his death, the last have come. And till that time, no will was produced before the court. The will was for the first time produced in 2020. That was have been executed in 2000. And before that, I gave the earlier number, that 4857 dependent number 2 was a party. Lingamma died at that time. He came as an elder. He did not say that Lingamma had executed everything in my favor. At that time only he should have said the will was there. He did not say it all. And rather.
Who are the other appellants? You are the defendant number 4. Who are second and other appellant? 2, 3, and 4.
And 4 are the other.
Other?
Other sons of Lingamma.
Illa. They are not party before the trial court. They must be. No, your appeal memo says they are LRs of one of the defendant, madam. With regard to this defendant, appellant number 2 to 4, they were not parties in the suit. They are LRs of defendant number 3. Right. So these LRs were not parties. So have you filed an application for grant of leave? What is order sheet? All right. Barcode. Who's appearing for respondent? Akarsh Kumar Gowda. Ah. You're the plaintiff. Ah. Ah. So there is any order in that? No order. What is the stage in that? There's no order of stay. You don't know, madam. Stay nodi 1734 ಅಲ್ಲಿ ಇದೆಯಾ? Next case. They have not taken stay in the connected matter. No. Third learned counsel, Srimati Mukund. Madam, your name is correctly spelled? Your name is correctly spelled in the cost list? Then so correct? TAI. All right. Sonatai. All right. Third learned counsel Srimati Vakun Sonatai on behalf of appellant. Mainly orders first RFA number 1904 of 21. See, the person who has now filed the suit against you is the second defendant. That is Venkatesh. Venkatesh. No. Based on the finding of will, is that is Srinivas. So he is no more. All right. All right. Third so and so. Learned counsel seeks indulgence of this court to consider IA number 2 of 22. Full stop. It is seen that notice to respondents number are 2, 5, 6, and 8. The postal shara is returned as delivery confirmed and having served item delivered. In view of the said postal shara, notice to R2, 5, 6, and 8 is held sufficient and is deemed as served. Registry to show their name in the cost list. With regard to respondents number 3 and 4, the postal shara is returned as refused. Accordingly, the notice to them also is held as sufficient and registry to show their name in the cost list as served. Notice to respondent number 9 is returned as no such person, and the appellant is directed to take out notice to respondent number 9. What about 7? Served already. Already. Orders on IA number 2 of 22. This application is filed by the appellant appellants, wherein the appellant number 1 was the defendant number 4 before the trial court, and appellants number 2 to 4 are the LRs of defendant number 3. We'll stop. It is the contention of learned counsel for the appellants that the suit came to be filed by the plaintiff, respondent number 1 plaintiff, for the relief of declaration and partition. However, the suit came to be dismissed. While dismissing the suit, an issue was raised in the suit proceedings being issue number 3 as to whether the defendant number 2 proves that the mother of the parties executed a will dated 15/11/2000 in favor of defendant number 2. This issue has been held in the affirmative in favor of the defendant number 2 before the trial court. Full stop. Based on the said finding in the suit, despite the dismissal of the suit, the defendant number 2 before the trial court has initiated ejectment suit. No? Number? Has initiated original suit for ejectment as against the appellants herein in OS number 3611 of 2022, which is pending adjudication. Full stop. The appellants herein are questioning the finding arrived at with regard to issue number 3, wherein the will has been shown to be proved in favor of defendant number 2. Full stop. It is also relevant to note here that the plaintiff who has suffered the dismissal of the suit has also filed an appeal, which is connected with this appeal in RFA 1734 of 2021. Full stop. In view of the original suit having been filed based on the finding arrived at by the trial court in OS number 4500 of 2011, granting the benefit of the proof of will in favor of defendant number 2, on the strength of which defendant number 2 has filed a suit for ejectment of the plaintiff, the appellants here in OS 3611 of 2022. This application deserves to be considered. Accordingly, it is on perusal of the affidavit and being satisfied with the same, I deem it appropriate to stay the operation of the judgment and decree passed in OS number 4500 of 2021, dated 22/2/2021, on the file of 15th Additional City Civil Judge at Bengaluru. More specifically with regard to issue number 3, wherein the will is proved in favor of the defendant number 2. Yes. In the IA, the net counsel for the appellant is permitted to carry out the corrections raised by the office with regard to IA number 2 on mentioning the original suit number. She submit that she will do the needful during the course of the same is permitted. Ivagale Madi. Now, what about the next? Your matter in non-compliance, you have to comply. ಯಾರು ಕೊಡ್ಬೇಕು ನೀವು? Your plaintiff. So she is sailing with you. You have to give it to the other defendant. In the connected matter, RFA 1734, Learned Counsel for the appellant seeks time, 2 weeks time granted to comply. Paper book to be filed within 12 weeks. Two weeks granted. Request of learned counsel for appellant. Okay. Out of sheet. Who are you? Your suit came to be dismissed. So you are seeking ejectment against defendants 1, 2, and 3. So no relief against D4. The counsel for the appellant is present before the court. He submits that defendant number 4 is at Bangalore Development Authority is arraigned as defendant number 4 before the trial court. The suit against defendant number 4 came to be dismissed by order dated 11/11/2014, quite prior to the pronouncement of judgment. The registry has raised objection with regard to non-arraying of defendant number 4 in this appeal. In view of dismissal of the suit against defendant number 4 as far back as 11/11/2014, the question of arraying said defendant before this, the said defendant in this appeal does not arise. Moreover, learned counsel for the appellant submits that he is not seeking any relief as against defendant number 4, that is BDA. Hence, the objection raised by the registry is overruled. Yes, it has to come for admission or delay of his registry to list IAS if any. Two weeks. In a memo withdrawal. All right. The counsel for the appellant seeks time, 2 weeks time granted. Pannappa,
My lordship, appearing for the appellants, my lordship, we may be permitted to withdraw the suit to file it in the appropriate court. And your lordship.
madam,
may
you are
direct-
not audible. You are submitting in this serial number 20.
Yes, my lordship.
You are not
I'm-
audible.
My lordship, we may be permitted to withdraw and file it.
I
in
cannot hear
appropriate-
you. You rectify your system.
My lordship, am I audible, my lordship? My lordship, we are appearing for the appellant. We may be permitted to withdraw this and file it in appropriate court, my lordship.
Delete evaluation. Evaluation parent appeal.
My lordship. My lordship, we may be permitted to withdraw this and file it in appropriate court. And I request your lordship to kindly direct the office to return the court fee.
Yes, madam.
My lordship, we may be permitted to withdraw this and file it in the appropriate court of law. And kindly
So it
direct
is
the
seen
office.
from the valuation slip furnished by the appellant. The subject matter of the appeal is valued for recovery of money of rupees 2 lakhs with interest.
Request your lordship to kindly direct the
How
office
this
to return
19(1)
the court.
apply in this case? How 19 will apply? Madam,
My
how
lordship,
19(1) will apply? You are not audible.
we may be
Learned
permitted to
counsel
withdraw
for
it
the
and file
appellant,
it in
though
appropriate
present
court.
through video conferencing and visible. Her audio is extremely poor and she is not audible. Learned counsel to make her submission next week by rectifying the audio of her system, computer system. Full stop. Relist this matter week after next.
Number 21.
But this is a specific performance suit decreed in your favor. Now he wants to deposit 14 lakhs. Oh, you can deposit. We welcome deposit of money. Now, what is the original stage of this appeal? Sir, this appeal is 2017. Now, because of his IA, which is filed, it's come up for IA. Whether matter is listed for hearing. You have objection. What objection? Correct. Now your specific performance suit is decreed in your favor. He has challenged that. Now he wants to deposit amount. Let that amount lie in the High Court. You argue the matter. And again, prejudice agalla. This court is not going to get prejudiced merely because he deposits the amount. This court is going to hear on the merits of the matter, and of course, it is on record that he is now depositing the amount, which was not his case in the original suit. So you are not going to be prejudiced. Kodi. ಅಲ್ಲಿ ಪುವರ್ ಫೈನಾನ್ಷಿಯಲ್ ಕಂಡೀಷನ್ ಸೂಟ್ ಅಲ್ಲಿ ಇತ್ತು, ಇವಾಗ ದುಡ್ಡು ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ನಾವು ಈಸ್ ಡಿಸೈಡೆಡ್ ಟು ಡೆಪಾಸಿಟ್ ಮಾಡ್ಲಿ, ಇದನ್ನ ಇಟ್ಕೊಳ್ಳೋಣ. ಕಾಸ್ಟ್ ಹಾಕ್ಬೇಕಾದ್ರೆ ನಿಮಗೆ ಕೊಡ್ಬೇಕಾಗುತ್ತಲ್ಲ. What is the order passed? Stay of further execution proceeding. In the execution. So the trial court has come to a conclusion that it is an agreement of sale. It is their case that it's a loan. Now, what was their case in the written statement before the trial court? So that was their statement even before the trial court. to show that the particular property value is much greater than the mentioned in the agreement. For the orders on IA number 1 of 22, ಅದಕ್ಕಿಂತ ಮೇಲೆ learned counsel Sri Supreet, yes, for the appellant is present before the court physically. So also learned counsel Sri Shantakumar SP for the respondent plaintiff. Orders on IA 1 of 22. 1 of 22 and production of documents. We'll deal with this first. This application is filed by the appellants who are the defendants before the trial court. Appellants who are the defendant before the trial court. Full stop. The appellants have sought permission of this court to deposit a sum of rupees 14 lakhs in the guise of hand loan by demand draft number so and so drawn on Bank of Baroda, Kolar branch, Kolar. Full stop. Various grounds are urged in the affidavit annexed to this application, which is not adverted to by this court. Full stop. Learned counsel for the respondent has filed a detailed statement of objections to this application, contending seriously that this is an afterthought of the appellants to deposit this amount, as he had not made a single effort before the trial court or either during the pendency of the suit or immediately after the judgment, but has now come up with this application to deposit this amount of 14 lakhs after a period of 6 years. After a period of 6 years, learned counsel for the respondent contends that there is disputes the fact that there was any loan transaction between the parties. This court is not inclined to express any opinion on whether the amount being sought to be deposited is a hand loan or not, or otherwise. Full stop. The judgment and decree passed by the trial court is for performance of the contract, which is decreed in favor of the respondent plaintiff. It is also stated by the learned counsel for respondent that he has deposited the balance sale consideration amount of rupees 1 lakh before the trial court itself or executing court. A balance sale consideration of 1 lakh, and what remains is only the execution and registration of the sale deed in favor of the respondent plaintiff. Full stop. The matter was admitted and listed for hearing on the main appeal itself. In the meanwhile, this application is filed. I have heard the learned counsel for both the parties. I do not find any prejudice that would be caused to either of the parties if this amount is deposited by the appellant. The amount is sought to be deposited before this court. You are depositing it in the name of Registrar General. Full stop. As stated earlier, this court was not expressed any opinion with regard to the nature of the transaction between the parties and the deposit of the amount being either loan transaction or otherwise, which will have to be dealt with in the main appeal. So also, no advantage would be caused. It is made clear that no advantage would be caused or would benefit the appellant in depositing this amount with regard to the main appeal on merits of the matter. Register the IA number 1 of 22 is allowed. The appellant is permitted to deposit the amount of rupees 14 lakhs by way of demand draft number so and so. Same defined number is the same. Demand draft number so and so dated so and so before this court. Full stop. Next orders on. What is this IA number 2? Who was filed? IA number 2 of 2017 is filed by the appellant for production of additional documents. You have filed objections for that? We'll consider it along with me. All right. This application will be heard along with the main. Correct, sir. We'll have to hear that. This court will have to hear you. I'm not disposing that. In the main arguments, you take all the contentions. Everything is left open. This application will be considered along with the main appeal. List this matter for hearing in seniority. How old is that appellant? Respondent? Huh? 73. When was the early hearing allowed? Sorry. Full stop. It is seen that prior to the filing of this application, the stage of the appeal was for hearing on the basis of an early hearing application having been allowed on 9/6/2022. The suit being of the year 2016, 16, and the respondent being aged 73. This appeal request to be heard expeditiously. Therefore, list this appeal in the third week of October. In the third week of October. Yes, Mr. Ariga. Passover. What is the setting aside order recalling?
This was the first
No, what is the setting aside order of 28(3)?
There was some dispute with regard to the quantum of the motion. That was adjusted and there's a clear cut out when it's on the court, why are you getting 2019? There is a why I moved on that because every court is an order to direct other side to pay that regularly as per March 2019 order. The other side was not regular in trade. Therefore, every time they to make a memo. Directing the seeking direction to the other side for depositing the rent. That's how the matter came up before our court of Friday. And incidentally, this was the court question. So what is the
Now, the order of 28(3)19 is to deposit 5 lakhs within 3 weeks. Admadi, they have deposited. Now they are regularly paying rent.
They concern the matter came. As of the date, they have paid that.
All right. So that IA would not survive.
IA would not survive.
You have filed that IA.
They are vacating the interim. I filed vacating interim order on the road that they are not deposited. Subsequently, they filed.
What is that IA? filed by you. No, that is not listed anyway today.
Now, I moved a memo. Seeking a directive to deposit the arrears of rent.
Sir, Mr. Council, that arrears of rent, everything is done till December, what she is saying. Already, bantala munde heli, why you are going back?
This was the question posed to the other.
All right, so now this application of setting aside 28(3) order will not arise. We'll dispose it off. Barkoli. Is that IA? It has to be heard now on the main matter. Mr. Ariga, that IA which you have filed one for setting aside that order of 28(3)19 would not survive for consideration because your colleague says that you have paid now an entire arrears. That will
The matter has been taken of attention. Was brought to the notice of the court that there is no evidence at all. That was looking good. And I was asked to file a memo of that. And my learned friend also filed a memo of that. After that, the order is to be passed on 20th February 2019. Then court will directed I shall deposit rupees 10 lakhs within 4 weeks.
all right, all that is done now. So I'll dispose it off and hear you on merits.
Here come minutes, weeks.
No, not today. Now, what is your defense?
I defense is funny. Notice, communication, that is the basic of the proceeding, is only to the dependent who is not the tenant. Tenant is a partnership consists of 8 partners. There is no notice of termination to the government. That is the basic defense. And then on other courts also I have. Because the termination goes into the two companies. There is no termination at all.
Kindly refer the exhibit to the, there is a reply notice. Para number 3. My client says that the option made is para one of the notice to that is a direct agreement.
The written statement.
The reply notice
Reply no.
given by them, exhibit P3 and exhibit C.
What is the relationship between plaintiff and defendant? What is their relationship? No. There is no other relationship. Yes.
If there is no termination, if there is no termination of tenancy, then the exclusion of pay.
So you are questioning that 106 of TP Act notice. Where is the issue? Is there an issue? And second issue, valid termination of tenancy, held in the affirmative.
There is a legal and valid termination.
Barcode. Then counsel for the appellant, Sri Chandranath Ariga is present before the court. So also learned counsel Sri K. Ramesh for respondents 1 to 3. Orders on I number 1 of 2020. This application is filed by the appellant. 1 of 20. Respondent ಅಂತ ಹಾಕಿದ್ದೀರಾ, you are appellant, right? Respondent ಅಂತ ಹಾಕಿದ್ದೀರಾ? Affidavit ಅಲ್ಲ one of the respondents ಅಂತ ಇದೆ. Appellant has filed the appeal. What is this? You have your appeal, IE 1. Lakkanna, ಯಾರಿದು? 20. Ah. Correct. You have the copy of IA. Who's L. Lakkanna? You have filed that.
That application was right because getting the
Oh no. You have filed setting aside the order 28.3. ಏನ್ರಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾರೆ ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಅವ್ರ ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ ಅಂತೀರಾ ಯಾವ್ದ್ರಲ್ಲಿ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ ಸರ್ ಯು ಪ್ಲೀಸ್ answer the question of court properly with regard to who was filed which IA. Is filed by you. Okay. So now you are agreeing that entire amount has come and you want to withdraw what do you? Okay. Learned counsel for the respondent has filed this application seeking to set aside the order dated 28/3/2019 and to dispose of the matter on merits. Subsequent to filing of this application, a memo of calculation has been filed by the appellant seeking permission of the court to deposit the monthly rents, and he has deposited the rent which is not disputed and the same is affirmed by learned counsel for the respondent. Learned counsel for the appellant also submits that he has paid the entire arrears of rent as on date, which is not disputed by the learned counsel for respondent. In view of such submission, IA number 1 of 2020 would not survive for consideration, which is also accepted by the learned counsel appearing for the respondent who has filed the present application. Accordingly, IA number 1 of 2020 does not merit consideration as the entire arrears of rent is admittedly paid by the appellant to the respondent. As this IA is disposed of, as the entire arrears of rent is deposited by the appellant. Stop. What is the other IA for listing? Memo of mediation. We'll list it for arguments on main. That memo of calculation is filed by you. In view of the memo of calculation, next para, in view of memo of calculation having been filed by the appellant, which is accepted by the respondent, same does not deserve the no orders are required to be passed on the such memo, as the entire arrears are admitted to have been paid by the appellant, which is accepted and acknowledged by learned counsel for the respondent. Since the pleadings are complete, paper books are filed. Raise this matter for final hearing in the third week of October. ಅದೇನು ಹೇಳಿಲ್ಲ ಪೇಪರ್ ಬುಕ್ ಫೈಲ್ ಅಂತ ಹೇಳಿಲ್ಲ ಪೇಪರ್ ಬುಕ್ ಫೈಲ್ ಅಂತ ಇಲ್ಲ ಅಲ್ಲ IA1 for listing is filed by whom? You. So that is listed. So IA number 1 of 2022 is also disposed of as the matter has been listed in accordance to the said IA. Registry is directed not to show the said IA in the costas anymore. Relist on in the third week of October for final hearings. Non fix madak baralla. On priority. Sharat Kumar Venkataswamy. Huh? Declaration and recovery of possession. Hmm. Your defendant yaro. What is your relationship with the defendant? Your father, sisters, cousins. All right. So where were you working? What is the suit property? Who was filed adverse possession? Now, what are you seeking here? You're claiming title over the property on what document? Registered. Registered. What are these registered sale deeds now on 79 and 88? P18 and P19. Sir, P18 and P19. You don't know. Who's this Lakshmama? Huh? What is your cause of action? What is your cause of action date? What is the prayer in your plaint? Page? So your second prayer is for mandatory injunction to quit and deliver vacant possession. On what basis? You're seeking for possession. Not a mandatory injunction agreed. Your case is not that they are in permissive possession. They took permission from you and they are in possession. That's your case. Father allowed you. Where are you? Where is the question of your giving permission? There's a difference between mandatory injunction for possession and suit for possession. From when they are in possession, according to you. 1978. How's your suit is dismissed on the ground of limitation, Mr. Counsel? Mate, how you are going to? What is the question? Limitation baralwa. That is considered a negative. You're Sharat Kumar. Third Learned Counsel for the appellant. Issue notice on IA and main to the respondent. Let notice go on come. What injunction? Your suit has to be dismissed at the admission stage itself. Your appeal. Let them file objections. IA number 1 of 2022 shall be considered after objections are filed and service of notice on the respondent. There is no great urgency. You are out of possession according to you. They are in possession. Or barely objection akli. Yes, Jagannath. And list it on 30th. I will list it on 30th. You can find out. Why should I treat it as part heard? No, that you no, you take your time. Why you bind yourself and why I should bind myself to this? No, you'll call it on the reopening day. No difficulty. But I cannot treat it as part heard because it is coming up for admission. It is not in the final hearing also. It may not be appropriate. You're right. No, you're right, and you have more information than me. What, Mr. Shetkar? For what? Every submission of learned counsel cannot be recorded, sir. Counsel is making submission on the basis of what is. We don't know that tomorrow the client may turn against him. I did not make. You must have seen several clients. I never said so. My counsel has made. Why should we bind the counsel for the fault of the client? No, he had argued. No. I think Mr. Jagannath had argued for some interim order, I guess, not to interfere. So that was not. I think we have not decided that application yet. This is that bearing. All right. So we'll leave it as that. Anyway, you are not prejudiced by any of the order passed. No order is passed. Let him inquire and speak to his client and let them take a decision on proper advice from him. So I'll merely adjourn it. Barkoli, both the learned. You're naming an urgency there.
They have expressed their intention not to leave.
About what?
You all.
Appeal. Withdraw.
Okay, appeal.
Ah.
Next.
No, but there's no order against you. So what is stopping you? It is a vacant site. Now you're putting up construction and you showed that photographs and all. You proceed, there's no order against. Learned Counsel Sri Jagannath KM is present before the court, representing the appellant, and the Sri Shivarudrappa Shetkar on behalf of the respondent, respondents. Learned Counsel for the appellant submits that he needs some time to seek necessary instructions from his client to proceed in the matter. Placing his submission on record, deem it appropriate that the matter be listed during the 3rd week or 4th week. When do you want? October. 4th week of October. Yes. Wise decision. Yes, Kantarajappa. Yaru, ನೀವು ಯಾರು? Your dependent? Plaintiff? What happened? So defendant number 8 is declared as absolute owner of item number 2. You are challenging that. And also this one. All right. So your case is that your mother could not have sold to defendant number 8. And you are claiming 1/3 share instead of 1/4. That's your case. Hmm. 23, 1. From your mother. Illa. 23/196 ಏನದು? By whom? That is what your mother sold it to defendant number 8. So 23/1/1996 is a gift deed. So 23/196 is the sale deed purchased by your mother. 6/4 is a gift deed. 2. 110/15.
Different number 6 and 7 also scored different number 8, 28/9/2016. Same term.
ಅದು ಯಾರು ಸೇಲ್ ಮಾಡಿದ್ರು ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್? Sold to D8. So the gift deed which was given by your mother on 6/4/2015 to defendant number 2, your brother, entire property.
No, item number 2, rescheduled property only.
All
Same property is split up in the different number 8.
Different.
Item number 6 rescheduled.
No, you said 110/15, again it was sold to defendant number 15. Oh, take it easy. On 110/15, you said defendant number 15 was, this property was sold to defendant number 15. Then what remains? Then how defendant number 6-7 sold to 8?
28/9/2016.
Correct, Ray. What was sold to D15? Then same property is sold to D8 also.
D8 is sold for the D8.
Huh?
This is number 6 and 7. Number 8 is sold.
ಅವ್ರಿಗೆ ಎಲ್ಲಿ ಬಂತು ರೈಟು 6 and 7ಗೆ?
Some 50 brothers, sold.
So defendant number 2 is your brother who gets the gift deed.
There is sold now.
ಯಾರಿಗೆ?
Number 6 and 7.
ಎಷ್ಟು?
The letter number 2.
ಮತ್ತೆ what is sold to defendant number 15?
Number 15.
ಏನಿಲ್ಲ. Then what is this 110 15?
Number 9.
What about 110 2015? What is that document? By whom to whom? They are third parties, you know, defendant number 6 and 7. They are not your family members. So 6 and 7 sold it to D8. So now you are challenging that gift deed. You are challenging the gift deed. Sale deed. Hmm. The property is purchased by your mother. It becomes her property. It becomes her property.
My father is purchased. My mother is stated that her father was mother. Division number 3. Previously stated.
Karkoli. Third Learned Counsel, Sri Kantarajappa MG for the appellant. This appeal being continuation of the suit proceedings would have to be considered on the merit once again by reappreciation and reevaluation of the entire materials on record placed by both the parties. Accordingly, it requires consideration. Hence, appeal is admitted. Registry to secure trial court records. Paper books to be filed in 12 weeks. Issue notice to respondent. And orders on IE number 1 of 22. There shall be stay of the operation and execution of judgment and decree dated 16/8/2022 in OS number 121 of 2017. Passed by the additional senior civil judge and JMFC at Davangere till next date of hearing. This is the matter which you argued the other day.
Entering modern records. Do whether I am.
The plaintiff, you're the plaintiff. Your suit came to be dismissed. Hmm. So Baswaraj is the plaintiff. Hmm. On what ground your suit came to be dismissed?
On ground that if the defendant forward certain contentions on the basis of the written statement, another law to the other states.
That you should have filed a suit for.
That it has also been the opinion from the legal set and other responding to the construction.
In which para?
Page 41, paragraph 14. We have been one minute stop.
Mm-hmm.
85 years. Has taken opinion to legal set. Other rule of making responding to the schedule of construction. That he has to file a suit for recovery of his property. To be noted from the part, the suit property is standing in the name of both the individuals. They was declared the defendant. Volunteer that he told out of the day on the day of for this mission, clearly complicated. The suit for inaction not this.
It is not the case of defendant that he is in possession. So also the trial court has not come to a conclusion that defendant is in possession. Of course. Heard Learned Counsel Sri V.B. Shivkumar for the appellant plaintiff. Issue notice to the respondents. This appeal is a continuation of proceedings of the suit. This court would have to reappreciate, re-evaluate the material evidence on record, along with the exhibits produced by both the parties. If the matter requires consideration accordingly, appeal is admitted. Registry to secure trial court records. Paper books to be filed in 12 weeks. Orders on IA number 1 of 2022. This application is filed. No, you're okay with an order of status quo.
Status quo with regard to publish.
Yes. This application is filed by the appellant under order 39 rule 1 and 2. Full stop. Read with section 151 CPC. For an order restraining the respondents from attempting or interfering and dispossessing the appellant or taking forcible possession of the social property, which is in lawful possession and enjoyment of the appellant, pending disposal of the appeal. Full stop. Along with this appeal, Learned Counsel for the appellant has filed an affidavit today with certain documents, which include photographs of the suit schedule property, wherein the appellant is seen. So also the property tax paid receipt for the year 2022-2023, and also the electricity bill for the period 11th August 2022 to 11/9/2022 to demonstrate that the appellant plaintiff is in absolute peaceful possession and enjoyment of the scheduled property. Before passing any order on this application, I deem it appropriate to issue notice on this application as well, to call for objections, if any, by the respondent on appearance, and decide the matter on merits. In the meanwhile, the documents produced by the appellants prima facie depict that the appellant is in possession and enjoyment of the property, and he has paid the tax as well as the electricity charges of the suit scheduled property. Without expressing any opinion on the merits of the matter, I deem it appropriate to pass the following order. Status quo to be maintained with regard to nature, possession of the suit scheduled property in question till next date of hearing. The respondents are at liberty to file objections to the application IA number 1 of 2022 till next date of hearing. Status quo. Yes.
Official, I was fine. Your office just be clarified whether it should be. I have no problem, unless somebody check. Partition.
Correct.
So if you property 60 by 38, they have valued it for 50 lakhs in the trial court. Some same value. The officer should not be as per today's market value. We have reported.
Where is the valuation slip? The market value of the property is more than 15 lakhs. All right, we'll send it there. All. Learned counsel for the appellant. Your Ram Mohan? Sri Ram Mohan. He is present before the court. He submits that as per the, you are the plaintiff appellant, or who are you? Defendant suit, or whose appeal is this?
My opinion, I have lost it. The
Defendant. The subject matter of the value of the suit property is more than 15 lakh as per the valuation slip filed by the respondent plaintiff before the trial court. You have not filed that value here.
I find the same valuation sheet, even I have added in the club, it is more than 50 lakhs. Valuation.
The learned counsel for the appellant has filed a memo of the valuation, and he has stated that the property, subject matter of the property is valued at rupees 54,72,000 and plaintiff's half share is around 27,36,000. And he has also stated the matter will have to be heard before the division bench in view of the value of the subject matter of appeal being more than 15 lakhs. Placing the submission on record and also the memo of valuation, this matter would have to be placed before the division bench. Registry is directed to place this matter before the honorable division bench for consideration. The counsel for the appellant submits that he has already filed second set registry to verify and put up. Sorry, yeah. Sorry.
So my question number two.
Sampath Kumar. Sharat S. Gowda, Anandita Chakrabarti. Next.
Are you ready, seven? Then be ready.
Discussed meeting and said that they have nothing to discuss with them. We have discussed only before the last.
What was this? What is this? On what transpired on the previous date? What is this property subject matter? Hmm. Use the mic. You're able to hear me. Use the mic so that I can hear you. Press it down. ಅದು ಆನ್ ಆಗಿರೋದನ್ನ ಆಫ್ ಮಾಡಬೇಡಿ. Yes. There is a registered seal executed in his favor. In nominal sale deed andre no. What is nominal sale deed? And what prevented you from saying so in the sale deed that it is security, it is a mortgage, as and when you will repay that amount, they will have to give back? Now, if that is considered, then everybody who sold the property about 10 years back or 15 years back, and when the property boom happens, they will come and say so.
That's one mistake. Trying to see, he just found something.
Have you got that produced and marked in the court? Did you make it as a document in support of your case? Ah. All right. All right.
Some who executes the sale as too much repetitive with their thoughts and avoid the sale. You don't go. They examine some in one of this that. To report the. Not the difference. I will agree with you. discuss. Who matter the- this, because the meaning is, that not really yeah, what do 1% is on none of the.
So your suit was filed only for declaration and permanent injunction. All right, is there any order here? All right, you want to not agree for any settlement, then you argue the matter. Argue the matter. 2017, your appeal. There is no order in your favor. You have any interim order here? Status quo, he is in possession on the basis of sale deed. You will continue. It is not going to help you, status quo order. Huh? Like 2 acres, 33 guntas. They are cultivating the crop. From when? Beginning andre ಏನು? Sir, beginning andre, yeah, when is the beginning according to you? Mr. Counsel, please understand. I don't know when the beginning starts for you. When is that beginning date? Is there a date or the beginning? ಮತ್ತೆ Adam and Eve. Beginning andre Adam and Eve. Huh?
From 1983. 1993.
From 1993. Hmm.
The entire family is a question of power.
From 93.
All the input is
Hmm.
year 2009. 2008 or 2009.
Hmm. You are not in possession.
But what is the commission? Which was filed. This is not agriculture, is there, that,
All right, whether are you willing for any talks on settlement or you are not willing? Or you want to repay the amount? Are you agreeable?
That means that's interest of.
But you have not placed that before the court.
Payment is very cheap. Cash is also paid.
Mr. Gangireddy, you say that you have paid some amount as interest. That is by cash or check?
Cash.
Where is the endorsement? Have you produced it? No, that you should place it and argue. How can we take it across?
Yeah, this is amount from
The records idea. What is the court fee you have paid for in this suit? ₹25. 25 rupees you have paid. Now he says he's in possession. You say you're in possession. He says he's in possession continuing from 93.
Clearly admit that they never had the permission. But subsequently, revenue records got entered into the public data. But the defendant's files the statement. The person who executes the sale never stepped into the law to prevent and say that sale was nominal or the transaction was really not intended. But they examined one of the person who was not a person in sale.
All right, according to you, sale deed contains an averment and covenant that he has handed over possession. In the written statement filed by you, have you taken the plea that he is not in possession, you're in possession? You're taking the plea. Is there an issue on that before the court? Issue number 2. Correct. Correct. What is wrong in it?
Remand this matter to establish law. Remand the matter to establish law.
No, what stopped you from doing so?
The same also not in the room, minor history.
All right, I'll hear you. I'll hear you on the main. I'll hear you on the main. You can argue on the main matter. You're ready today? Good. Learned counsel for the appellant is present. So also learned counsel for the respondent. The parties to this appeal are present before the court. It appears that there is no more meeting point between both the parties for an amicable resolution. What is the value of the property now?
8 and 15 lakhs on the now all the lands
ಎಲ್ಲಿರೋದು ಇದು? Kolar. All right, he is not agreeable. Sir, 15 lakhs plus 5 lakhs. Correct, but that. Mr. Gangireddy, if the matter you want to settle, then it's between both of you outside the court, whatever transaction you want to execute, whatever amount you want to give, and if he's willing to receive. If he's not willing to agree, then I cannot do anything. You will have to argue the matter on merits. I'll list it after 3rd week of October. In the meanwhile, you can sit and talk, both of you.
What are you pushing for the party has come I sir, I question him. Many of them are there. Because we are not being participated.
What he says?
He said, our claims must still prevent people poor. Except the SAP you already put transaction. What he said, You're not ready to talk to me.
Your clients are here. Your clients are here. ಯಾರು ಚೆನ್ನಪ್ಪ ಯಾರು? ಮುರಳಿ ಮುರಳಿ ಯಾರು? ಮುರಳಿ ಲಕ್ಷ್ಮಣ 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 ಯಾರ್ರೀ? ಮುರಳಿನೂ ಬಂದಿಲ್ಲ, ಲಕ್ಷ್ಮಣನೂ ಬಂದಿಲ್ವಾ? ಯು ಆರ್ ನಾಟ್ ಏಬಲ್ ಟು ಹಿಯರ್. ಯು ನಾಟ್ ಏಬಲ್ ಟು ಹಿಯರ್. Murli and Lakshmana both have not come. Nagaratnam, who's the third person here? Who's the third person here? Who's the person who was executed sale deed? First defendant Chanappa. He's here. This pen. Or ನಿಮ್ಮ ಹತ್ರ ಖರೀದಿ ಮಾಡಿದಿರಲ್ರಿ ನರಸಿಂಹಮೂರ್ತಿ ಅವರು, ನಿಮ್ಗೆ 15 ಲಕ್ಷ ಕೊಟ್ಟು ಖರೀದಿ ಮಾಡಿದಾರಲ್ಲ ಜಮೀನ್, ಮಾಡಿಲ್ವಾ? ಸರಿ, ಮತ್ತೆ ನಿಮಗೆ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಸೇಲ್ ಡೀಡ್ ಇದೆ ಅವ್ರ ಹೆಸರಿಗೆ, ನೀವು ಅವ್ರ ಜೊತೆ ಕೂತ್ಕೊಂಡು ಮಾತಾಡಕ್ಕೂ ತಯಾರಿಲ್ಲ. ಮಾತಾಡಕ್ ತಯಾರಿದ್ದೀರಾ? ಮತ್ತೆ ಹೋಗಿ ಕೂತ್ಕೊಂಡು ಹೊರಗಡೆ ಮಾತಾಡಿ. If your client wants to show his ego, then he can keep it with him. Then why are you coming in the way? See, as it is, you have suffered a decree. You want some amicable resolution based on your terms, you have to go to his door. He need not come to you. He is already enjoying the benefits of a judgment in his favor. No doubt this appeal is still yet to be decided and this court will decide on merits. If you want to talk on some settlement, you have to approach him or he's come here. If you are adamant and not approaching, I will say you are not agreeing and proceed with the matter. Go outside and you can talk. Barkoli, the counsel for the appellant so and so. Wait, Aitala and Sri Suresh Kumar for the respondent is present before the court. Both the parties to the proceedings are present. They intend to talk on settlement to amicably resolve the issue if possible. Same is permitted. Hence, to facilitate them for the process of settlement and to report settlement if any, release this matter in the 3rd week of October. You can go and talk whatever you want. Any order is there. Status quo. Status quo will continue. Let him argue. Already list this matter in the 3rd week of October.
Number 1, 2, 3, 5 to bring the law on the car. I already tried to the law on the law. More questions to not. Item number 4 and 5 is person not there. Please in the
Yes, in second matter, year number 1.
No objection to allow this CH-21.
All right.
Item number 4 and 5. The tenants who are noticing before are not contesting this.
In the trial court?
They are not contesting. The tenants are already vacated.
Located. What is this suit filed for? Whose appeal is this? Plaintiff's appeal. What happened to the suit? What happened to the suit? Dismissed.
On the ground that the plaintiff has not proved the bill, issued by their grandmother.
Plaintiff's appeal. 224.
My friend is representing.
Yaro?
This is the nation academic.
No, 224 is to Sitapa. This is by defendant's appeal. You don't know whose appeal. I don't know, in the final hearing stage, you're still struggling to understand whether you're plaintiff or defendant. How do you come to High Court with such unpreparedness? I don't understand. You're in High Court, sir. At least you should know for whom you're appearing. That shows your carelessness. Second matter is plaintiff's appeal. Your matter is defendant's appeal. Defendant 1 and 2. So two different suits. Why is it called together?
Because the second case is not going by the. Simultaneously, right?
No. In the appeal filed by in 363 RFA. Correct. Plaintiff is Saravanan, the appellant is Saravanan.
No, yes, ma'am. Plaintiff is Saravanan in this case. The next case will not be appellant is Saravanan. Plaintiff suit is dismissed in the law by the trial court. I think next week will not be plaintiff has prepared this. Ultimately, see the class rating.
Yes.
Saravanan is none other than the son of the second defendant. The second respondent is Bhoganathan. And he is not the grandson of Draupadi Bai. He executed the bill in the year 1980 in respect of two property. One situated at Railway Travel Road, another situated at Atamanagar.
Let us take this first appeal, the 363, in which that Saravanan is the plaintiff.
Only the plaintiff.
In that the suit is filed for what relief?
Saying that the grandmother executed the bill is not for declaration, declaring that the grandmother is not at all executed the bill.
All right. In the second suit, that is Mukesh Kumar Jain, 95, 97, 51 of 2005. Possession already, ನೀವು ಏನನ್ನ ಹೇಳ್ತಾರೆ ejectment ಅಲ್ವಾ? The ejectment on the basis that he's a tenant. Trespasser. So in both the appeals, it is the in one case it is Saravanan, in the other case it is Saravanan and his father. Who are you appearing for? Who are you appearing? Huh? Yarge? First if what happened to your suit? Agreed. Defendants are directed to vacate, deliver vacant possession of the suit property within 6 months, failing which plaintiffs are at liberty to take possession through process of court. Damages to the tune of 2,000 per month, date of suit till realization. All right. So what is the subject, the suit settled property in this case? is the schedule? What is the schedule? Where is the decree? Decrees. Huh? Where is the decree? Who is the appellant in 224? VB Shivkumar. Siddhappa. ಏನ್ರಿ ಸುಮ್ಮನೆ ನಿಂತಿದ್ದೀರಲ್ಲ? Now, where is your decree in the appeal? Paper book ಇದೆಯಾ? ಕೊಡಿ. Page number? What is the settled property? The 510 square feet is the ejectment you are seeking, which is decreed. All right. What is the schedule in the other property? Where is that? Where is that up? Council? Where is the appellant? ನೀವು ಯಾರಿಗೆ? Respondent number 2 in the second matter.
The son will be appellant, the son number 2 will be father. Another son will be father. Who's the name?
ಯಾರು?
I saw property in my editor of property.
All right. You are appearing for respondent number 2. Father. So in the other case, you are for the first respondent, you are appearing.
B63 of proposal 7 who won the property in respondent is
The other matter, that is 224. 224, you are not made a party. 224, Mr. Siddhappa, in 224, you are appearing for whom? Appellant, both the appellants. So, in this 224, you are appearing for both father and son. In the second matter, you are appearing only for son, and he is appealing for the father. ಹೌದಾ? ಯಾರಿಗೆ? ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅಲ್ಲಿ in 363 you don't want to appear for the appellant? Huh? Ilri, ಈ 363 ಅಲ್ಲಿ in 363 Mr. Leeladhar is appearing for respondent number 2, defendant number 2, who's the father. In 363 the appeal is filed by the plaintiff Saravanan, who's the son. You are the person appearing for him in the connected appeal. Mehetar M. Azam is shown NOC, VB Shivkumar has given NOC to you. You don't want to appear for them in the connected appeal 363. All right, you address arguments. What is it for? Main arguments? Ready? Yes, you argue. Huh? Barcode.
Item number 4 and 5 is concerned, they are already vacant.
Where is this? IA number 1363.
Appellant is also not to go to court. Home melody in my brain get a position on their behalf.
Sir, you don't address arguments to each other. That you can do outside the court.
Already paid.
Who are these people? First defendants, Yella. Who was the first defendant?
This is Nagapatnam. Nagapatnam. Who is the beneficiary of the deed? The beneficiary of the deed, who would have done already for the property. Respondents in the court. Why can't you run after the Vakala before?
You already come on record.
Already made Vakala?
So this D. Nagabhushanam is the one who sold the property to
the respondents in
that is the plaintiff in 3020.
No, plaintiff in 97, 85 something.
No. In this OS number 3020.
And the Bakras fund. I sold the property in favor of the respondent. Plaintiff before the
In which OS 3020.
next case.
Sir, when I'm asking this case, why you argue about other case?
He is my brother's son. He is 3020. Plaintiff is my brother's son.
In 3020 ಅಲ್ಲಿ ಕೇಳ್ತಾ ಇದ್ರೆ ಅದಕ್ಕೆ ಆನ್ಸರ್ ಮಾಡಿ. You want to create more confusion amongst all of you, then you can create yourself. 3020 is a suit filed by Saravanan for the relief of declaration and possession. In this case, he has come in appeal. The suit is dismissed. Correct. Now he is to file this application to bring the legal representatives of defendant, first defendant. So first defendant is Nagabhushanam. He has died. The LRs are to be brought on record. So what is the relief sought for in this declaratory relief is against the first defendant?
Yeah.
All right, but the LRs are required to be brought on record. Barcode. Orders on IA number 1, 2, 3 of 2021. These 3 applications are filed by the appellant to bring on record the legal representatives of deceased first defendant whose arrayed as first respondent is in this appeal. To stop, it is stated that the first defendant died on 28/12/2020, and the legal representatives are sought to be brought on record as R1, A, B, and C.
Yes, sir.
A, B, and C. Full stop. Notice was issued, and the LRs of defendant number 1 are represented by learned counsel KC Praveen, whose name is shown in the cause list as appearing for R1A to C. He is present before the court and he submits that he has no objection in the LRs of the first defendant being brought on record. Do you have any objections? The others? All right, Barcoli. I have perused the affidavit annexed to this application. The reasons unsigned and the cause shown therein are sufficient. Accordingly, the delay of 100 days in filing the LR application is condoned. IA number 1 of 2021 is allowed. Whether there is any order of abatement as against R1 formally. Full stop. The IA number 2 and 3 are filed to set aside abatement and to bring the legal representatives on record. In view of condoning the delay of filing the LR application, I deem it appropriate to allow IA number 2 and set aside the abatement as against respondent number 1. Consequently, IA number 3 of 2021 is allowed. The legal representatives of deceased respondent 1 bar defendant 1 are permitted to be brought on record as R1, A to C, A, B, and C. The learned counsel for the appellant to carry out the necessary amendment in the cause in the appeal memo by incorporating the amendments in the appeal memo by file and also file a amended appeal memo by serving a copy of the same on the other side. Yes, what is the next non-taking of what? Yeah, R3 to 8, 3 and 8. What about no steps have been taken in respect of respondents 3, 7 and 8. It is stated that these respondents are none other than tenants of the suitable property and that they have vacated the suitable property. The appellant is not represented through a counsel. You want to take notice or you want to appear for appellant? No. Appellant is not represented through a counsel. If steps are not taken in respect of R3, 7 and 8 by next date of hearing, the appeal would be dismissed as against respondents number 3, 7 and 8. Full stop. Learned Counsel Sri N. Raghu Babu has also filed wakalat on behalf of R1 A to C, along with Learned Counsel KC Praveen, registry to show his name in the cost list as counsel appearing for R1 A to C in RFA 363 of 2017. To stop. It is seen that RFA number 224 of 2017, the two appellants are represented by Learned Counsel Sri B.M. Siddhappa, who is present before the court physically. In RFA 363, the appeal is preferred by one Sri L. Saravanan, who is none other than the second appellant in the aforestated appeal. There is no representation on behalf of the appellant in RFA 363 of 2017. Learned Counsel for the appellants in RFA 224 on being inquired as to whether he would like to take notice and appear on behalf of the appellant in the second appeal, that is RFA 363, shows ignorance of in the matter and does not want to appear on behalf of the appellant. Let it be. Let it be. He's representing that Saravanan in your case. So, Mr. Liladhar, Saravanan is represented by him in this. Mate?
I heard him Azu.
Really? Really? You are representing that Saravanan in the earlier case. You don't want to represent him in this case. All right. He's not here. All right. All right. Because he is representing him, he cannot show ignorance. Barkoli. Will and wish of the parties to engage a lawyer. When his lawyer is representing in one case, he doesn't want to appear in this, will be noted. Then we pass an order. It is seen that though Learned Counsel Mehtar M. Azam is representing the appellant, he is not present before the court. However, the very same appellant is represented by Learned Counsel Sri Siddhappa in the connected RFA. If the said counsel does not appear for the appellant on the next date of hearing, adverse orders will be passed as against him, which may affect the interest of the appellant. The same cannot be questioned later on for non-representation of the appellant. You cannot play hide and seek before this court, Mr. Liladhar. Parties cannot think that they want to play hide and seek before the court. No, it is not that he's absent. He is also appearing for him. Yaudrally? Yarge? R2. All right. Learned Counsel Sri H.P. Liladhar has filed NOC Wakalat from previous counsel Sri G.S. Venkata Subba Rao on behalf of R2. Hence, in view of the same, registry to delete the name of Learned Counsel Sri G.S. Venkata Subba Rao from the cost list. Yes. This Rashekar. Yes, yes, Mr. Senior Counsel, you are sitting quite some time. Yes. Yes. ಏನಿದು ಫೈನಲ್ ಇಯರಿಂಗ್ 2017 ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಇನ್ನೂ ಡಿಸ್ಪೋಸ್ ಆಗಿಲ್ವಾ?
Part of the property have been sold. Those structures are not. But it is an issue is fine. Value order voting.
This is IA 13 ಅಲ್ಲಿ. IA 13. IA 13. In IA number, you want to bring the subsequent purchases on record to impede them. And what about IA 1 of 17? That is for stay. ಅದು ಇನ್ನೂ ಆಗಿಲ್ಲ, ಕನ್ಸಿಡರ್ ಆಗಿಲ್ಲ.
Which revival of RSA. I do not know the factor of tax rate. After the decrease of RSA, and after when the passed, after when I claim some percentage of after decalculating of RSA is not right. From that request, now the global purchases of property on me, which now they want to keep in the party. I appear for them and award them as once the party sale on me, because I represent them as such.
So you are appearing for the purchasers. No, but
and also my vendors and even from the person who purchased from me, all these and also the purchasers from private appear.
The question regarding this matter is indicated. I am saying so. You know, one house of was having 4 divisions. One of the after minimizing that house partner, then may not one of the son file a file number 70 for the land. Land for the last and occupancy. Occupancy rate was of the land and that did not own. Later on, another 3 brothers are filed a food by the party. The question now is secondary to the application. It is disputable in an application filed by one person. And the occupancy rate was standard in use for whether any of the benefits or something are not, and that's how the opinion is. The trial court and both the courts of the good. It's a tendency in the benefit of all the countries and start to be challenged. In secondary, one is all very question of law. Second question of law is what suppose we had foreign members under the anti-foreign side of the world, both client family as well as family hobby. Family is defined to very limited and narrow circle. Joint family rule of what is applicable to joint family. It's a Muslim law that the parties are. It is regulated therefore to every part of section 2 subsection 7 required limit of the family. Now the question will be why the foreign members. A person make a declaration that foreign family means overall the family. Whether the courts will on the basis of border address to enlarge the scope of that what was fulfilled or declared by him, which is another question to be reviewed. Therefore, we not the matter to be discussed. Many of it takes parties will be added. The case will be fixed. We are ready to argue. Or any day immediately after because I understand
Then fortunate of me, I have got these matters. I was in the office of the 12. There when the 26 is going on, before 21 is going on, before the charge is going on, I rushed immediately. From 9 o'clock to 12 o'clock, my laptop is sometimes explained. I'm not fully ready, I have to say what. But I should get ready with the matter. I should have a proper assistance to the office. Immediately after the case. Detention for logic. It happens. I think that. I think that. But as a.
All right. Anyway, you're ready in the matter. So what you do, you file a list of synopsis kind of a thing on the next date of year. You file it so that he can also file it. What Mr. Senior Counsel says is that he's not fully ready. It's not that he's not ready. He is not fully ready. So we have to respect his statement. Let him get ready in address arguments. Nothing, heaven is not going to fall in a couple of weeks. You already from 2 to 5 years agide. Yes, of course.
My endeavor is.
What is the suit filed for? Oh, who has filed the suit for what? What happened to the? No, what happened to the suit? Is revived. All right. If there's a question of law that is framed and that has to be decided, it has to be decided. We will expedite.
Subsequent all but if I fail and we are not part of what the force do, then our consequences follow today.
All right. Now that there is a checkered history of this litigation, it is better to assist the court. You file a list of synopsis and in a brief manner rather than filing not more than 4 pages. Yes, learned Senior Counsel Shri Rajgopal, M.R. Rajgopal is present, representing Shri on behalf of Shri S.N. Bhattala, S.N. Bhatt for the appellant. Oh, the first matter is RSA. That is a revived. RSA. But RSA November ಬರ್ದಿದೆ. Special order. ಮುಂದೆ. IA 13 orders on IA 13 of 2022. This application is filed by the appellant seeking to implead respondent number 7 to 11, who are the purchasers from the plaintiff, correct? Is who the respondents 13, respondent in number 7 to 11. It stated that the proposed respondents have purchased a portion of plain shuttle property on 18/1/2022 and 25/1/2022 from respondents number 5 and 6. And that they are proper and necessary parties in this proceedings. Full stop. Learned Counsel Sri Rajshekhar, yes, Rajshekhar. You are undertaking to file. You are not filed. When? That's why your name is not shown. Learned Counsel Sri S. Rajshekhar, who is already appearing on behalf of the other respondents. Others under R1 to R6, you know. R1 to R6. Submits that he has already filed wakalat on behalf of the proposed impleading respondent 7 to 11. Registry to show full stop. And he has no objection in these applicants or proposed respondents being brought on record. Full stop. I have perused the affidavit annexed to these applications. And being satisfied with the affidavit filed in support of the application, I do not find any legal impediment in allowing the application to implead the proposed respondents as 7 to 11 who are purchasers of the portion of the suitable property from respondent number 5 and 6. And wakalat having been filed by Learned Counsel S. Rajshekhar, who does not have objections. His application deserves to be allowed accordingly. It is allowed. Learned Counsel for the appellant to make the necessary amendments and corrections in the appeal memo and file the amended appeal memo by serving a copy of the same to Learned Counsel for the respondents. Full stop. All other IAs shall be considered later on. Full stop. What is the IA for stay and injunction? And
Day before yesterday, it was not extended to the other. The back order to be extended, but it just not. I'm looking up in the property. This one counter. We agree with the state. Service the way we have to take it. And it is the number of very important. I will not be that there is there are put on terms that the language is very important.
so now you don't want to give the tender. No, it's up to you. This court is not going to pressurize you.
I expect next day this subject their cooperation. I will ensure my last. I want to be here also. And I not take time and argument. So what as me is concerned, but I give you answer and give you they are good. That will not sign. I think you know what to do. I'm doing it. But now the engaged artist.
Then we will not make such an order. We listed. They are other same, you know. In RFA 1807 also there is an implement, similar application, similar order. Other file madidara neevu? All right, same order, madam. All right. Workwood. Learned Counsel for the respondent, C.S. Rajshekhar, fairly submits that he is not inclined to alienate the suitable property the condition that the matter would be argued without taking further adjournments. Learned counsel for the senior counsel for the appellant submits his would go on with the matter on the next date of hearing. Full stop. Relist this matter on in the third week of October. Date when I may not be in the position to give a date. Third week, that day when it comes. It's made clear that this shall not become a ruse or an excuse to the appellants to move the revenue authorities for any change of entries.